We've all heard those horror stories, right? Homeowners clashing with their HOA over the color of a mailbox or the height of their grass. But what happens when the fight isn't just about the rules, but about whether the rules are even being applied fairly? Today, we're diving into a case that starts out simple enough, but then takes a wild turn when the entire thing hinges on a tiny 5-day delay.
So, let's meet the players. On one side, you've got Matthew Petrovic, a homeowner in Phoenix, and on the other, you have his HOA, the Tatum Highlands Community Association. It's that classic individual versus the organization setup, but believe me, the details here are anything but ordinary. At first, it really looked like an open and shut case. On May 5, 2025, an administrative judge sided completely with the HOA. A pretty decisive loss for the homeowner, right? Well, for Petrovic, this wasn't the end of the road, not even close. It was actually the start of a much bigger fight.
So yeah, he decided to fight back. He filed a petition for a rehearing, and his argument wasn't just that the judge got a few details wrong. No, he argued that the entire decision, the whole process, was fundamentally flawed from the very beginning.
Okay, so to really get what he's arguing, you gotta know about the CC&Rs. Just think of these as the Constitution for a neighborhood. They are the official rulebook that everyone agrees to live by, and they became the absolute centerpiece of Petrovic's appeal. And his first point really shows you how detailed he got. The HOA dinged him for his sago palms. But Petrovic didn't just disagree, he came back with a 4-part defense. He pointed to the community's own rules, which he says permit the plants. He brought in expert info showing that sago palms aren't even technically palm trees. He had a witness back him up, and he even accused the HOA's witness of lying. He came ready. Then, you've got the paint on his house. The HOA said it was in disrepair. Again, Petrovic came prepared. He had 3 witnesses say the paint was perfectly fine. He pointed out that the HOA had approved that exact paint when he bought the house. But his strongest point was this. He claimed the HOA kept changing its reason for the violation, all while never providing a single photo or report as actual proof.
And you can see here, he wasn't just arguing about plants and paint. He felt like he was being targeted. In his own words, he raised serious concerns of selective enforcement and retaliation. He thought this was personal.
And that claim of selective enforcement? It gets a whole lot clearer when you look at the issue of a paver walkway. For 3 years, Petrovic had been asking for approval to build one, and he even provided a doctor's letter saying it was medically necessary. The HOA just kept denying it, even while, according to Petrovic, they were approving similar walkways for his neighbors.
And his final argument was a big one. He basically attacked the legal process itself. He argued he was denied due process because he was under the impression that the first hearing was just an informal chat, a mediation. He walked in expecting a conversation, not a full-blown trial. And because of that, he felt he never got a fair shot to actually prepare a real defense.
So Petrovic lays out this incredibly thorough case, right? It's all about evidence, fairness, and procedure. But the HOA's lawyers, well, they weren't interested in re-arguing about paint or palm trees. They found one tiny detail that they thought would shut this whole thing down. Instantly.
And this is where you see the two sides talking completely past each other. Petrovic is telling a story about what he believes is right and wrong. The HOA, on the other hand, is focused on one thing and one thing only, the black and white rules of the court. After all of Petrovic's detailed arguments about evidence and fairness and retaliation, the HOA's entire response came down to a single, simple number: 5. Just 5 days that they believed made everything else completely irrelevant.
See, the law is crystal clear on this. You have exactly 30 days after you get a decision to file for a rehearing. The decision came on May 5th, so the deadline was June 4th. Petrovic filed his request on June 9th, 5 days late.
And the HOA's lawyers, they did not mince words. They said the request must be denied. It was, quote, untimely filed and time barred. Now, in the legal world, missing a deadline like this is usually game over. It's an automatic loss. There are no do-overs. So this brings us to the crucial question. After all that work, all that evidence, all those arguments about fairness, was Petrovic's entire case really about to get thrown out simply because he was 5 days late?
All right, so all of this lands on the desk of the Commissioner of the Arizona Department of Real Estate, and they had to decide what matters more, the strict deadline or the substance of the homeowner's appeal. And in what was frankly a pretty surprising decision, they sided with the homeowner. Yep. Despite being 5 days late, Matthew Petrovic was granted a brand new hearing. That procedural flaw? It wasn't fatal after all. Their commissioner gave 2 really powerful reasons for this. First, they said there were potential errors in how the evidence was handled the first time around. And second, and this is a big one, they said the original decision might have been arbitrary, capricious, or an abuse of discretion. Now that's some strong legal language, but it basically means the ruling seemed to lack a fair or logical reason. And that was concerning enough to need a second look. So, what it all boils down to is this. The state decided that the story of the case, all those questions about fairness, evidence, and possible retaliation, was just too compelling to throw out over a 5-day delay. In this instance, the substance won out over the procedure.
So what does this win actually mean? Now, it's a huge deal, but it's important to know this isn't the end. Petrovic didn't win his case outright. He won the right to have his case heard all over again, right from the very beginning.
This timeline puts it all into perspective. You've got the original ruling against him in May, that late filing in June, and then the surprise decision in his favor in July. And it all leads to a brand new hearing on October 22nd, where both sides get to go at it all over again.
You know, this case really highlights a fascinating tension you see in any system built on rules. On the one hand, you need strict, unbending deadlines for things to function. But on the other, this decision proves that sometimes a really compelling story about fairness can be enough to convince someone in charge to bend those rules and take a second look.
And that leaves us with a final question to think about. We all live by rules, right? Whether they're from an HOA, a job, or the government. But a case like this makes you wonder, when is it okay to bend those rules? When should the story of what happened matter more than the procedure for how it's judged?